Good morning, Charlie Kirk. Hey, let me tell you a little about my talking animal, Marshall. You can talk to me and give me voice commands. Well, what should I call you now? Okay, from now on I'll call you Mr. Charlie Kirk. Woo! Good morning, Mr. Charlie Kirk. Hello, Mr. Charlie Kirk. I'm glad to see you again. United States Court of Appeals. For the Second Circuit. Underline, 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 at a stated term of the United States Court of Appeals for the Second Circuit, held at the Thurgood Marshall United States Courthouse, 40 Foley Square, in the city of New York, on the 9th day of August, 2019. Underline, 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 Julie Graham, Miami Herald Media Company, in the Venus Appellants. V. Gisela Maxwell, Defendant Hathaway, V. Virginia L. Jaffer, Plaintiff Hathaway. Underline, 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 underline. Order. Docket now, 18-2868. Hathaway, Gisela Maxwell, filed a petition for annual rehearing, or, in the alternative, for rehearing in bank. The panel that determined the appeal has considered the request for panel rehearing, and the active members of the court have considered the request for rehearing in blank. IPISHEREDYORDERED that the petition is denied. For the court. Kathleen O'Hagan Wolf, Clerk. Case 18, 2868, document 271, 08/09/2019, 2628203, page 101, selected docket entries for case 18, 2868 generated, 08/09/2019, 10/13/24. File document description page docket text 08/09/2019 272 order FILED20RDER dated 08/09/2019 directing the clerk to issue the mandate forthwith IJAC RST CFD FILED 2628208 18 2868 08/09/2019 273 judgment mandate issued. 2628218 18 2868 273 judgment mandate ISSUED4 273 supporting document 5 273 supporting document 30 08/09/2019 275 unsealed summary judgment report document 31, unsealed summary judgment report, appendix 1 of 13, pursuant to the court's decision dated July 3, 2019, DOCKETED. 2628223, 18, 2868, 08/09/2019 276 unsealed summary. Judgment report, document 49, unsealed summary judgment report, appendix 2 of 13, pursuant to the court's decision dated July 3, 2019, DOCKETED. 2628224, 18, 2868, 08/09/2019 277 unsealed summary. Judgment report, document 126, unsealed summary judgment report, appendix 3 of 13, pursuant to the court's decision, dated July 3, 2019, DOCKETED. 2628225, 18, 2868, United States Court of Appeals, for the Second Circuit. At a stated term of the United States Court of Appeals for the Second Circuit, held at the Thurgood Marshall United States Courthouse, 40 Foley Square, in the city of New York, on the 9th day of August, 2019. Before, Josh H. Abrams, Rosemary S. Poor, Christopher F. Droney, Circuit Judges. Underline, 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 underline. Julie Brown, Miami Herald Media Company, in the Venus Appellants, V. Ghislaine Maxwell, Defendant Appellate, V. Virginia L. Jaffer, Plaintiff Appellate. Order 18, 2868. Underline, 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 underline. Alan M. Dershowitz, Michael Cernovich, DVA Cernovich Media, in the Venus Appellants, V. Virginia L. Jaffer, Plaintiff Appellate, V. Ghislaine Maxwell, Defendant Appellate. 16, 3945, L. 17, 1625, con. 17, 1722, con. Underline, 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 underline. Case 18, 2868, document 272, 08/09/2019, 2628208, page 102 IPISHEREDYORDERED that the clerk is directed to issue the mandate forthwith. For the court. Kathleen O'Hagan Wolf, Clerk of Court. Case 18, 2868, document 272, 08/09/2019, 2628208, page 202, United States Court of Appeals, for the Second Circuit. at a stated term of the United States Court of Appeals for the Second Circuit, held at the Thurgood Marshall United States Courthouse, 40 Foley Square, in the city of New York, on the 3rd day of July, 2019. Before, Josh H. Abrams, Rosemary S. Poor, Christopher F. Droney, Circuit Judges. Underline. Julie Brown, Miami Herald Media Company, intervenors appellants. V. Gisela Maxwell, defendant appellate. V. Virginia L. Jaffer, plaintiff appellate. Judgment. Docket Nos. 18-2868. Underline. The appeal in the above caption case from a judgment of the United States District Court for the Southern District of New York was argued on the District Court's record in the parties' briefs. Upon consideration thereof, that the orders of the District Court entered on November 2, 2016, May 3, 2017, and August 27, 2018, the Court further ORDERs the unsealing of the summary judgment report as described in its opinion. The case is REMANDED to the District Court for a particularized review of the remaining materials. For the Court, Kathleen O'Hagan Wolf, Clerk of Portman Edmund ISSUEDOM 08/09/2019 Case 18-2868, Document 273, 108/09/2019, 2628218. Page 1 of 118, 2868, 16, 3945 CV, L. Brown v. Maxwell, Dershowitz v. Jaffer, in the United States Court of Appeals, for the Second Circuit, a U.S. term 2018, no, 18-2868 CV. Julie V. Brown, Miami HLC Company, intervenors appellants, V. Gisela Maxwell, defendant appellate, V. Virginia L. Jaffer, plaintiff appellate. No. 16-3945 CV, L. No. 17-1625 COM. No. 17-1722 COM. Alan D. Dershowitz, Michael C. Ernovich, Josh C. Ernovich Media, intervenors appellants, Case 18-2868, Document 273, 208/09/2019, 2628218, Page 1 of 25-2. V. Virginia L. Jaffer, plaintiff appellate, V. Gisela Maxwell, defendant appellate, asterisk. On appeal from the United States District Court for the Southern District of New York. March 6, 2019. Decided July 3, 2019. Before CADRANDS, TOOLER, and DRONEY, Circuit Judges. Intervenors appellants Alan Dershowitz, Michael Cernovich, and the Miami Herald Company, with reporter Julie Brown, appeal from certain orders of the United States District Court for the Southern District of New York, Robert W. Sweet, Judge, denying their respective motions to unseal filings in a defamation suit. We conclude that the asterisk the Clerk of Court is directed to amend the captions as set out above. Case 18-2868, Document 273, 208/09/2019, 2628218, Page 2 of 25-3. District Court failed to conduct the requisite, particularized review in ordering the sealing of the materials at issue. At the same time, we recognize the potential damage to privacy and reputation that may accompany public disclosure of hard-fought, sensitive litigation. We therefore clarify the legal tools that district courts should use in safeguarding the integrity of their dockets. Accordingly, we VACATE the District Court's orders entered on November 2, 2016, May 3, 2017, and August 27, 2018, ORDER the unsealing of the summary judgment report as described further herein, and REMAND the cause to the District Court for particularized review of the remaining sealed materials. Judge Moore concurs in this opinion except insofar as it orders the immediate unsealing of the summary judgment report without a remand. SANFORDOVOHRER, Christine M. Waltz, Madeline J. Harrington, New York, NY, on the Reef, Holland and Knight LLP, Miami, FL, for intervenors appellants Julie Brown and Miami Herald. TYGEE, Adam Mueller, on the Reef, Adam, Morgan and Foreman, PC, Denver, CO, for defendant Appley Gislam Maxwell. Case 18, 2868, document 273, 208/09/2019, 2628218, page 3 of 25-4. PAULGCASSEO, Sigrid S. Macaulay, North Shore Flexner LLP, Fort Lauderdale, FL, on the Reef, S.J. Quinney College of Law, University of Utah, Salt Lake City, UT, for Plaintiff Appley Virginia L. Jaffer. NDREWGCLIJR. David A. Levowitz, on the Reef, Emily, Shelley, Brinkerhoffen of LLP, New York, NY, for intervenor appellant Alan M. Dershowitz. MARCRANDAZZA, J. Marshall Wallman, Las Vegas, NV, on the Reef, Randazzo Legal Group, PLLC, Hartford, CT, for intervenor appellant Michael Cernovich. JOSACADRANES, Circuit Judge. Intervenors appellant Alan M. Dershowitz, Michael Cernovich, and the Miami Herald Company, with reporter Julie Brown, jointly the Herald, appeal from certain orders of the United States District Court for the Southern District of New York, Robert W. Sweet, Judge, denying their respective motions to unseal filings in a defamation suit. We conclude that the District Court failed to conduct the requisite, particularized review in ordering the sealing of the materials at issue. At the same time, we case 18, 2868, document 273, 208/09/2019, 2628218, page 4 of 25-5. Recognize the potential damage to privacy and reputation that may accompany public disclosure of hard-fought, sensitive litigation. We therefore clarify the legal tools that district courts should use in safeguarding the integrity of their dockets. Accordingly, we the ACATE the District Court's orders entered on November 2, 2016, May 3, 2017, and August 27, 2018, ORDER the unsealing of the summary judgment report as described further herein, and REMAND the cause to the District Court for particularized review of the remaining sealed materials. Background. A. Jeffrey Epstein's conviction in the CVRA suit. The origins of this case lie in a decade-old criminal proceeding against financier Jeffrey Epstein. On June 30, 2008, Epstein pleaded guilty to Florida state charges of soliciting and procuring a person under the age of 18 for prostitution. The charges stemmed from sexual activity with privately hired masseuses, some of whom were under 18, Florida's age of consent. Pursuant to an agreement with state and federal prosecutors, Epstein pleaded to the state charges. He received limited jail time, registered as a sex offender, and agreed to pay compensation to his victims. In return, prosecutors declined to bring federal charges. Shortly after Epstein entered his plea, two of his victims, proceeding as Jane Doe 1 and Jane Doe 2, filed suit against the government in the Southern District of Florida under the Crime Victims' Rights Act, CVRA. The victims sought to nullify the plea. Case 18, 2868, document 273, 208/09/2019, 2628218, page 5 of 25-6. Agreement alleging that the government failed to fulfill its legal obligations to inform and consult with him in the process leading up to Epstein's plea deal. Point 1. On December 30, 2014, two additional, unnamed victims, one of whom has now self-identified as Plaintiff Appley Virginia Jaffer, petitioned to join in the CVRA case. These petitioners included in their filings not only descriptions of sexual abuse by Epstein, but also new allegations of sexual abuse by several other prominent individuals, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders, as well as Dershowitz, a one-time member of the Harvard Law School faculty who had worked on Epstein's legal defense, and defendant Appley Gislam Maxwell. 2. Dershowitz moved to intervene, seeking to strike the outrageous and impertinent allegations made against him and to request a show cause order to the attorneys that has made them. The exercising its authority to strike from a pleading an insufficient one, on February 21, 2019, the Florida District Court ruled that federal prosecutors had violated the CVRA by failing to adequately notify the two victims' plaintiffs of the plea deal. The District Court has not yet determined the appropriate remedy. See WoOE v. United States, 359 F Sup. 3D 1201, 120417, SD Flaw. 2019. 2 WoOE v. United States, No. 08CV, 80736KAM, 2015 W011254692, at Astos 2, SD Flaw. April 7, 2015, internal quotation marks omitted. The internal quotation marks and brackets omitted. Case 18, 2868, document 273, 208/09/2019, 2628218, page 6 of 25-7. Defense or any redundant, immaterial, impertinent, or scandalous matter. On its own, for the Florida District Court, Ken A. Mara, Judge, sua sponte struck all allegations against additional parties from the pleadings, including those against Dershowitz, and therefore denied Dershowitz's motion as moot. 5. The stricken allegations, however, quickly found their way into the press, and several media outlets published articles repeating Jaffer's accusations. In response to the allegations, on January 3, 2015, Maxwell's publicist issued a press statement declaring that Jaffer's allegations against Ghislaine Maxwell are untrue and that her claims are obvious lies. 6. V. Jaffer sues Maxwell. On September 21, 2015, Jaffer filed the underlying action against Maxwell in the Southern District of New York. Jaffer alleged that Maxwell had defamed her through this and other public statements. Extensive and hard-fought discovery followed. Due to the volume of sealing requests filed during discovery, on August 9, 2016, the District Court entered a sealing order that effectively ceded control of the sealing process to the parties themselves. The sealing order disposed of the requirement that the parties file individual letter briefs to request sealing and prospectively granted all of the parties forfeit. R-Civ. P12F. 501, 2015 W011254692, at Astos 23. 6C Jaffer v. Maxwell, 325 F Sup. 3D 428, 434, SDNY 2018. Case 18, 2868, document 273, 208/09/2019, 2628218, page 7 of 25-8. Future sealing requests. In total, 167 documents, nearly 1/5 of the docket, were filed under seal. These sealed documents include, inter alia, motions to compel discovery, motions for sanctions and adverse inferences, motions in limine, and similar material. On January 6, 2017, Maxwell filed a motion for summary judgment. The parties submitted their memoranda of law and supporting exhibits, contesting this motion under seal. On March 22, 2017, the District Court denied the motion in a heavily redacted 76-page opinion. Once again, the entire summary judgment report, including the unredacted version of the District Court opinion, denying summary judgment, remained under seal. On May 24, 2017, Maxwell and Jaffer executed a settlement agreement, and the case was closed the next day. See motions to intervene and unseal. Over the course of the litigation before Judge Sweet, the outside parties attempted to unseal some or all of the sealed material. On August 11, 2016, Dershowitz moved to intervene, seeking to unseal 3 documents that, he argues, demonstrate that Jaffer invented the accusations against him. On January 19, 2017, Cernich, an independent blogger himself, described popular political journalist, Seven moved to intervene, seeking to unseal the summary judgment report, and Dershowitz joined his motion. On April 6, 2018, after the case had settled, the Herald moved to intervene and unseal 7 VR. Appellant, Cernich, 4. Case 18, 2868, document 273, 208/09/2019, 2628218, page 8 of 25-9. the entire docket. The district court granted each of these motions to intervene, but denied the related requests to unsealing orders entered November 2, 2016, May 3, 2017, and August 27, 2018, respectively. The appellants timely appealed from each of the orders, denying their respective motions to unseal. Although each appellant seeks the release of a different set of documents, all argue that the district court failed to analyze the documents individually or properly apply the presumption of public access to court documents. We therefore order that the appeals be heard in tandem and held argument on March 6, 2019. On March 11, 2019, we issued an order to show cause why we should not unseal a summary judgment motion, including any materials filed in connection with this motion and the district court's summary judgment decision. 8. The parties timely filed their responses. E. Discussion. There are two categories of sealed material at issue in these appeals. 1. The summary judgment report, which includes the parties' summary judgment briefs, their statements of undisputed facts, and incorporated exhibits, and 2. Court filings, made in the course of the discovery process and with respect to motions in limine. In this opinion, we explain that our law requires the unsealing of the HIF of the Maxwell, No. 18, 2868 CV, docket No. 138. Case 18, 2868, document 273, 208/09/2019, 2628218, page 9 of 2510. Summary judgment materials and individualized review of the remaining sealed materials. While the law governing public access to these materials is largely settled, we have not yet adequately addressed the potential harms that often accompany such access. These harms are apparent. Over 40 years ago, the Supreme Court observed that, without vigilance, courts' files might become a vehicle for improper purposes. 9. Our legal process is already susceptible to abuse. Unscrupulous litigants can weaponize the discovery process to humiliate and embarrass their adversaries. Shielded by litigation privilege, combat actors can defame opponents in court pleadings or depositions without fear of lawsuit and liability. Unfortunately, the presumption of public access to court documents has the potential to exacerbate these harms to privacy and reputation by ensuring that damaging material irrevocably enters the public record. We therefore take the opportunity to describe the tools available to district courts in protecting the integrity of the judicial process and emphasize the court's responsibility to exercise these powerful tools. We also caution the public to critically assess allegations contained in judicial pleadings. 9. Nixon v. Warner Commerce, Incorporated, 435 U.S. 589, 598, 1978. 10. See Notes 46-47 in accompanying text. Post. Case 18, 2868, document 273, 208/09/2019, 2628218, page 10 of 2511. A standard of review. When reviewing a district court's decision to seal a filing or maintain such a seal, we examine the court's factual findings for clear error, its legal determinations de novo, and its ultimate decision to seal or unseal, for abuse of discretion. 11. View the summary judgment materials. With respect to the first category of materials, it is well settled that documents submitted to a court for its consideration in a summary judgment motion are as a matter of law judicial documents to which a strong presumption of access attaches under both the common law and the First Amendment. 12. In light of this strong First Amendment presumption, continued sealing of the documents may be justified only with specific, on the record, findings that sealing is necessary to preserve higher values and only if the sealing order is narrowly tailored to achieve that aim. 1311 Bernstein v. Bernstein Ludwigsberger and Grossman LLP, 814 F3D 132, 139, 2D Circle 2016. 12 Rudish v. Pyramid Company Onondaga, 435 F3D 110, 121, 2D Circle 2006. We observe that our holding in Rudish relies on the general principle that parties may be assumed to have supported their papers with admissible evidence and non-frivolous arguments. At 122, insofar as a district court has, through striking a filing, specifically found that assumption inapplicable, the categorical rule in Rudish may not apply. See Notes 42-43 in accompanying text. Post. 13 at 124. Examples of such countervailing values may include, depending on the circumstances, preserving the right of an accused to fundamental fairness in the jury selection process. Press enter. Company v. Superior Court Case 18-2868, Document 273, 208/09/2019, 2628218, page 11 of 2512. In this case, the District Court erred in several respects. Point 1 first, it failed to give proper weight to the presumption of access that attaches to documents filed in connection with summary judgment motions. The District Court reasoned that the summary judgment materials were entitled to a lesser presumption of access because summary judgment was denied by the court. 15 in assigning a lesser presumption to such materials, the District Court relied on a single sentence of dicta from our decision in United States v. Amodio. Point 16 we have since clarified, however, that this sentence was based on a quotation from a partial concurrence and partial dissent in the D.C. Circuit, and is thus not the considered decision of either this court or the D.C. Circuit. 17 in fact, we have expressly rejected the proposition that different types of documents might receive different in California, Riverside P. 464 U.S. 501, 510, 1984, the protection of attorney-client privilege, Rouge, 435 FCD at 125, the danger of impairing law enforcement or judicial efficiency, SEC. Visa Street Com, 273 FCD 222, 232, 2D Circle 2001, and the privacy interest of those who resist disclosure. 14-hour discussion here focuses specifically on the District Court's denial of the Herald's motion to unseal the entire record. Because this decision grants relief to all appellants, we need not discuss any separate, additional error in the District Court's denial of the earlier motions to unseal. 15 JIFR, 325 X-UP, 3D at 444, 1671 F3D 1044, 1049, 2D Circle 1995, Amodio II. One judge in the District of Columbia Circuit has pointed out, for example, that where the District Court denied the summary judgment motion, essentially postponing a final determination of substantive legal rights, the public interest in access is not as pressing. Internal quotation marks omitted, emphasis in original. 17 Rouge, 435 F3D at 121. Case 18-2868, Document 273, 208/09/2019, 2628218, page 12 of 2513. Weights of presumption, based on the extent to which they were relied upon in resolving a motion for summary judgment. 18 second, in contravention of our precedent, the District Court failed to review the documents individually and produce specific, on the record, findings that sealing is necessary to preserve higher values. 19 instead, the District Court made generalized statements about the record as a whole. Point 20 this too was legal error. Finally, upon reviewing the summary judgment materials in connection with this appeal, we find that there is no countervailing privacy interest sufficient to justify their continued sealing. Remand with respect to these documents is thus unnecessary. Accordingly, and to avoid any further delay, 21 we order that the summary judgment documents, with minimal redactions, be unsealed upon issuance of our mandate. Point 22. 18 at 123, 19 at 124, 20C, for example, JIFR 325 X-UP, 3D at 445, summarily concluding that all summary judgment judicial documents openly refer to and discuss these allegations of sexual assault and sexual trafficking in comprehensive detail, and that those allegations establish a strong privacy interest here. 21 compare. Rouge, 435 F3D at 127, ordering that the mandate shall issue forthwith to expedite the unsealing process. 22 upon issuance of our mandate, a minimally redacted version of the summary judgment record will be made accessible on the Court of Appeals docket. We have implemented minimal redactions to protect personally identifying information such as personal phone numbers, contact lists, birth dates, and social. Case 18-2868. Document 273, 208/09/2019, 2628218, page 13 of 2514. See the remaining saved materials. The law governing disclosure of the remaining saved material in this case is only slightly more complex. The Supreme Court has recognized a qualified right to inspect and copy judicial records and documents. 23. In defining judicial records and documents, we have emphasized that the mere filing of a paper or document report is insufficient to render that paper a judicial document subject to the right of public access. 24. Instead, the item filed must be relevant to the performance of a judicial function and useful in the judicial process in order for it to be designated a judicial document. 25. As our precedent makes clear, a court performs the judicial function not only when it rules on motions currently before it, but also when properly exercising its inherent supervisory powers. 26. As security members, we have also redacted the names of alleged minor victims of sexual abuse from deposition testimony and police reports, as well as deposition responses concerning intimate matters, where the questions were likely only permitted and the responses only compelled because of a strong expectation of continued confidentiality. She said, R.Civ. T5.2. While we appreciate the views expressed in Judge Bloor's separate opinion, the panel majority believes that the efforts invested by 3 former district judges in reviewing these materials adequately address those concerns. 23. Nixon, 435 U.S. at 597-98. 24. United States v. Amonio, 44 F3D 141, 145, 2D Circle 1995, Amonio I. 25 year. 26 compare. United States VHSBC Bank USA, NA, 863 F3D 125, 135, 2D Circle 2017, explaining that, in considering whether the report of a monitor charged with assessing compliance with a deferred prosecution agreement is a judicial case 18, 2868, document 273, 208/09/2019, 2628218. Page 14 of 2515. Document is thus relevant to the performance of a judicial function if it would reasonably have a tendency to influence a district court's ruling on a motion or in the exercise of its supervisory powers without regard to which way the court ultimately rules, or whether the document ultimately in fact influences the court's decision. 27. Accordingly, if in applying these standards, a court determines that documents filed by a party are not relevant to the performance of a judicial function, no presumption of public access attaches. 2.8. Once an item is deemed relevant to the exercise of judicial power, the way to be given the presumption of access must be governed by the law of the material at issue in the exercise of Article I judicial power and the resultant value of such information to those document. If the district court's conception of its supervisory power in this context were correct, the monitor's report would quite obviously be relevant to the performance of a judicial function and useful in the judicial process, internal quotation marks omitted. Whether a specific judicial decision constitutes a performance of a judicial function is a question of law. Accordingly, we review such determinations de novo. At 134. 27 Amonio I, 44 F3D at 145-46, concluding that documents were relevant to the performance of a judicial function because they would have informed the district court's decision whether to discharge or retain a receiver. See also FTC. These standards in MGMT. Core. 830 F2D 404, 409, First Circle 1987, citing Federal Rule of Evidence 401 having any tendency definition of relevance in determining whether documents were judicial documents. 28. As we explained below, there are several, often preferable, tools beyond sealing that district courts can use to protect their dockets from becoming a vehicle for irrelevant and potentially defamatory accusations. See Section D, Post. Case 18, 2868, Document 273, 208/09/2019, 2628218, page 15 of 2516. Monitoring the federal courts. 29. Thus, while evidence introduced at trial in connection with summary judgment enjoys a strong presumption of public access, documents that play only a negligible role in the performance of Article II duties are accorded only a low presumption that amounts to little more than a prediction of public access absent a countervailing reason. 30 documents that are never filed with a court, but simply passed between the parties in discovery, lie entirely beyond the presumption's reach. 31. The remaining sealed materials at issue here include filings related to, inter alia, motions to compel testimony, to quash trial sub pronè, and to exclude certain deposition testimony. All such motions, at least on their face, call upon the court to exercise its Article II powers. Moreover, erroneous judicial decision-making with respect to such evidentiary and discovery matters can cause substantial harm. Such materials are therefore of value to those monitoring the federal courts. 32. Thus, all documents submitted in connection with and relevant to such judicial decision-making are subject to at least some presumption of public access. 33. 29. Memorial I 71 F3D at 1049. 30 at 1050, 31 32 at 1049, 33. In previous decisions, we have identified an important exception to this general rule. The presumption of public access does not apply to material that is submitted to the court solely so that the court may decide whether that same case 18-2868, document 273, 208/09/2019, 2628218, page 16 of 2517. Although a court's authority to oversee discovery and control the evidence introduced at trial really constitutes an exercise of judicial power, we note that this authority is ancillary to the court's core role in adjudicating a case. Accordingly, the presumption of public access in filings submitted in connection with discovery disputes or motions in limit is generally somewhat lower than the presumption applied to material introduced at trial or in connection with dispositive motions such as motions for dismissal or summary judgment. 34. Thus, while a court must still articulate specific and substantial reasons for sealing such material, the reasons usually need not be as compelling as those required to seal summary judgment filings. Here, the precise basis for the district court's decision to deny the motion to unseal these remaining materials is unclear. In the 3 paragraphs devoted to the issue, the district court emphasized the potential for embarrassment given the highly sensitive nature of the underlying allegations, and concluded that the documents sealed in the course of discovery were neither relied upon by the district court in the rendering of an adjudication more necessary nor helpful in resolving a motion. 35. It is therefore unclear whether the district court held that these materials were not judicial documents, and thus our material must be disclosed in the discovery process or shielded by a protective order. See S.Com. 273 F3D at 233. 34. Memorial I 71 F3D at 1049-50. 35. JIFR 325 F Sup. 3D at 442. Internal quotation marks and brackets omitted. Case 18-2868, document 273, 208/09/2019, 2628218, page 17 of 2518. Not subject to a presumption of public access, or found that privacy interests outweigh the limited right of public access. On either interpretation, however, the district court's holding was error. Insofar as the district court held that these materials are not judicial documents, because it did not rely on them in adjudicating a motion, this was legal error. As explained above, the proper inquiry is whether the documents are relevant to the performance of the judicial function, not whether they were relied upon. 36. Indeed, decision-makers often find that a great deal of relevant material does not ultimately sway their decision. And insofar as the district court held that privacy interests outweigh the presumption of public access in each of the thousands of pages at issue, that decision, which appears to have been made without particularized review, amounts to an abuse of discretion. 37. In light of the district court's failure to conduct an individualized review of the sealed materials, it is necessary to do so now. We believe the district court is best situated to conduct this review. The district court can directly communicate with the parties, and can therefore more swiftly and thoroughly consider particular objections to unsealing specific materials. Relatedly, the district court can obtain the party's assistance in effecting any necessary redactions and in notifying any outside parties whose privacy interests might be 36. See text accompanying notes 1218 and 2628, and T. 37, CNV City of New York, 607 FVD 923, 943 and 21, 2D Circle 2010, explaining that abuse of discretion is among pejorative legal term of art. Case 18, 2868, document 273, 208/09/2019, 2628218, page 18 of 2519, implicated by the unsealing. Accordingly, we remand the cause to the district court to conduct such a particularized review and unseal all documents, for which the presumption of public access outweighs any countervailing privacy interests. D. Protecting the integrity of judicial proceedings. While we disagree with the district court's disposition of the motions to unseal, we share its concern that court files might be used to promote scandal arising out of unproven potentially frivolous statements. 38. We therefore describe certain methods courts can employ to protect the judicial process from being co-opted for such purposes. The Supreme Court has explained that the very court has supervisory power over its own records and files to ensure they are not used to gratify private spite or promote public scandal or serve as reservoirs of frivolous statements for press consumption. 39. This supervisory function is not only within a district court's power, but also among its responsibilities. In practice, district courts may employ several methods to fulfill this function. They may, for instance, issue protective orders forbidding dissemination of certain material to protect a party or person from annoyance, embarrassment, oppression, or undue. 38. GIFR 325X up. 3D at 447. 39. Nixon 435 U.S. at 598, internal quotation marks. Case 18, 2868, document 273, 208/09/2019, 2628218, page 19 of 2520. Ordinance require that filings containing such material be submitted under seal. 40. If parties then seek to file such materials, the court may deny them leave to do so. 41. District courts may also seek to counteract the effect of defamatory statements by explaining on the record that the statements appear to lack credibility. Moreover, under Federal Rule of Civil Procedure 12F, the district court may strike such material from the filings on the grounds that it is redundant, immaterial, impertinent, or scandalous. 42. Because such rejected or stricken material is not relevant to the performance of a judicial function, it would not be considered a judicial document and would enjoy no presumption of public access. 43. Finally, inappropriate 40 said. R.Civ. P26, C. See also S.com, 273 F3D at 22930. 41C. For example, SDNY Electronic Case Filing Rules and Instructions, February 1, 2019 edition, Rule 6.1, http://newsdesk.governor/x/ecf%20 rules, %200201119%20 final PDF. 42 said. R.Civ. T12F. Courts may strike material from the pleadings either on its own or on motion made by a party. Although motions to strike material solely on the ground that the matter is impertinent and immaterial are disfavored when material is also scandalous, no such presumption applies. Compare Lipsky v. Commonwealth United Corps. 551 F2D 887, 893, 2D Circle 1976, see also Talbot v. Robert Matthews Distrib. Company, 961 F2D 654, 664, 7th Circle 1992. Allegations may be stricken as scandalous if the matter bears no possible relation to the controversy or may cause the objecting party prejudice. 1 Market Simple Incorporated v. Base 177 FRD 128 133 EDNY 1998. Motions to strike are not generally favored except in relation to scandalous matters. Alvarado Morales v. Digital Clip. Core 843 F2D 613 61718 First Circle 1988. categorizing as scandalous matter which impugn the character of defendants. 43 Amodioi, 44 FVD at 145. Case 18, 2868, document 273, 208/09/2019, 2628218, page 20 and 2521. Circumstances, district courts may impose sanctions on attorneys and parties under Federal Rule of Civil Procedure 11, C.44 cautionary note. We conclude with a note of caution to the public regarding the reliability of court filings such as those unsealed today. Materials submitted by parties to a court should be understood for what they are. They do not reflect the court's own findings. Rather, they are prepared by parties seeking to advance their own interests in an adversarial process. Although affidavits and depositions are offered under penalty of perjury, it is in fact exceedingly rare for anyone to be prosecuted for perjury in a civil proceeding. 45 Similarly, 44 in relevant part, Rule 11 provides, by presenting to the court a pleading, written motion, or other paper, an attorney or a represented party certifies that it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. The court may impose an appropriate sanction on any attorney, law firm, or party that violated the law is responsible for the violation. The sanction may include non-monetary directives in order to pay a penalty into court, or, if imposed on motion and warranted for effective deterrence, an order directing payment to the amount of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation. Said. R.Civ. P.U.N. See also Amodioi I. 71 FVD at 1049, describing sanctions available to the court. 45 Sonia Sotomayor and Nicole A. Gordon, returning majesty to the law and politics, a modern approach. 30 Suffolk U.L. Reverend 35, 47 and 52, 1996. Perjury cases are not often pursued. Case 18, 2868, document 273, 208/09/2019, 2628218, page 21 of 2522. Pleadings, complaints, and briefs, while supposedly based on underlying evidentiary material, can be misleading. Such documents sometimes draw dubious inferences from already questionable material or present ambiguous material as definitive. Moreover, court filings are, in some respects, particularly susceptible to fraud. So while the threat of defamation actions may deter malicious falsehoods in standard publications, this threat is non-existent with respect to certain court filings. This is so because, under New York law, which governs the underlying defamation claim here, absolute immunity from liability for defamation exists for all or written statements made in connection with a proceeding before a court. 46 Thus, although the act of filing a document with a court might be thought to lend that document additional credibility, in fact, allegations appearing in such documents might be less credible than those published elsewhere. 47. 46 Front, Incorporated v. Cowell, 24 NYCD 713, 718, 2015, see also Kelly v. Alvarino, 485 FCD 664, 666, 2D Circle 2007, adopting the reasoning of the district court explaining that this privilege is the broadest of possible privileges. Restatement, second, of Courts 587, 1977, a party to a private litigation or a private prosecutor or defendant in a criminal prosecution is absolutely privileged to publish defamatory matter concerning another in communications preliminary to a proposed judicial proceeding or in the institution of or during the course and as a part of a judicial proceeding in which he participates, if the matter has some relation to the proceeding. Let's see note 47, post. 47. While common law courts have generally interpreted the litigation privilege broadly, they nevertheless maintain an important, if rarely implemented, limitation in its scope. To qualify for the privilege, a statement must be material and pertinent to the questions involved. Front, 24 NYCD at 718, quoting Newman's case 18, 2868. Document 273, 208/09/2019, 2628218, page 22 and 2523. We have long noted that the press plays a vital role in ensuring the public right of access and in enhancing the quality and safeguards the integrity of the fact-finding process. 48. In faithfully observing its best traditions, the print and electronic media contributes to public understanding of the rule of law and validates its prima functioning as service for the public. 49. At the same time, the media does the public a profound disservice when it reports on parties' allegations uncritically. We have previously observed that courts cannot possibly discredit every statement or document turned up in the course of litigation, and we have criticized the use by the media of the somewhat misleading term court reports in referring to such items. 50. Even ordinarily critical E. Smith, 153 NY 214, 1920, 1897. It follows, then, that immaterial and impertinent statements are, at least nominally, actionable, particularly when they are so needlessly defamatory as to warrant the inference of express malice. Same. It seems to us that when a district court strikes statements from the record pursuant to said R. P12, on the ground that the matter is impertinent and immaterial, it makes the very same determination that permits a defamation action under the common law. We think the judicial system would be well served with our common law courts to revitalize this crucial qualification to the litigation privilege. 48. Westmoreland v. Columbia Broad. Sis. Incorporated, 752 F2D 16, 23, 2D Circle 1984, Quoting Grove Newspaper Company v. Superior Court, Norfolk T. 457 U.S. 596, 606, 1982. 49 Richmond Newspapers, Incorporated v. Virginia, 448 U.S. 555, 572-73, 1980, plurality opinion, internal quotation marks omitted. 50 Amodio II, 71 F3D at 1049. Case 18, 2868, document 273, 208/09/2019, 2628218. Page 23 and 25-24. Readers may take the reference to court papers as some sort of marker of reliability. This would be a mistake. We therefore urge the media to exercise restraint in covering potentially defamatory allegations, and we caution the public to read such accounts with discernment. Conclusion. To summarize, we hold as follows. 1. Materials submitted in connection with a motion for summary judgment are subject to a strong presumption of public access. 2. The summary judgment report at issue will be unsealed upon issuance of our mandate, subject to minimal redactions. 51. 3. Materials submitted in connection with and relevant to discovery motions, motions in limine, and other non-dispositive motions are subject to a lesser but still substantial presumption of public access. 4. The District Court is directed to review the remaining sealed materials individually and unseal those materials as appropriate. 51. See Note 22, Ante. Case 18, 2868, document 273, 208/09/2019, 2628218, page 24 and 25-25. 5. District courts should exercise the full range of their substantial powers to ensure their files do not become vehicles for defamation. For the foregoing reasons, we vacate the orders of the District Court entered on November 2, 2016, May 3, 2017, and August 27, 2018, ORDER the unsealing of the summary judgment report as described herein, and REMAND the cause to the District Court for particularized review of the remaining materials. In undertaking this task, the District Court may be well served by ordering the parties to submit to the court unredacted electronic copies of the remaining sealed materials, as well as specific proposed redactions. The District Court may also order the parties to identify and notify additional parties whose privacy interests would likely be implicated by disclosure of these materials. In the interests of judicial economy, any future appeal in this matter shall be referred to this panel. Case 18, 2868, document 273, 208/09/2019-2628218, page 25 of 25 TOOAR, Circuit Judge, dissenting in part. I join the court's opinion in every respect but one, the decision to unseal the summary judgment record ourselves. I agree that all or most of the material must be unsealed. Nevertheless, in my view, the district court is better suited to the task. As the court's opinion recognizes in connection with the remaining sealed materials, the district court is better positioned to communicate with the parties and any non-parties whose privacy interests might be affected by unsealing. On that score, it is worth clarifying here the regs of the court's unsealing order. It unseals nearly 2,000 pages of material. The task of identifying and making specific redactions in such a substantial volume is perilous. The consequences of even a seemingly minor error may be grave and irrevocable. Moreover, although I share the majority's concern about avoiding delay, I would radiate that concern through other means perhaps, with an order directing the district court to act expeditiously and by making clear what types of limited redactions are and are not appropriate. In sum, I would unseal the district court's summary judgment decision only, and leave the remainder of the materials for the district court to review, redact, and unseal on remand. Case 18, 2868, document 273-308/09/2019-2628218, page 101, United States District Court, Southern District of New York. Ex-Virginia L. Jaffer, plaintiff, v. Ghislaine Maxwell, defendant. 15 CV 07433 RWS. XDEFENDATENTSTATEMATERIALUNDISPUTED facts pursuant to Local Civil Rule 56.1. Laura A. Menner, Jeffrey S. Agliuca, Adam, Morgan, and Foreman, PC 150 East 10th Avenue, Denver, CO 80203, 303.831.7364. Case 18, 2868, document 207-08/09/2019-2628223, page 118-1. Pursuant to Rule 56.1 of the Local Civil Rules of this Court, Defendant Ghislaine Maxwell submits this statement of the material facts as to which she contends there is no genuine issues to be tried. Ms. Maxwell expressly preserves all of her objections to the admissibility of the evidence cited herein and in the accompanying memoranda of law and does not raise any objections on making this submission. Number 1. Ms. Maxwell's response to publications of plaintiff's false allegations, the March 2011 statement. In early 2011, plaintiff, in 2 British tabloid interviews, made numerous false and defamatory allegations against Ms. Maxwell. In the articles, plaintiff made no direct allegations that Ms. Maxwell was involved in any improper conduct with Jeffrey Epstein, who had pleaded guilty in 2007 to procuring a minor for prostitution. Nonetheless, plaintiff suggested that Ms. Maxwell worked with Epstein and may have known about the crime for which he was convicted. 2. In the articles, plaintiff alleged she had sex with Prince Andrew, a well-known businessman, a world-renowned scientist, a respected liberal politician, and a foreign head of state. 3. In response to the allegations, Ms. Maxwell's British attorney, working with Mr. Go, issued a statement on March 9, 2011, denying the various allegations about Ms. Maxwell that had appeared recently in the media. These allegations are all entirely false. 4. The statement read in full. Statement on behalf of Ghislaine Maxwell by Devonshire Solicitors, PRNE. Wednesday, March 9, 2011. London, March 10, 2011. Ghislaine Maxwell denies the various allegations about her that have appeared recently in the media. These allegations are all entirely false. Case 18, 2868, document 207-08/09/2019-2628223, page 2 of 18-2. It is unacceptable that letters sent by Ms. Maxwell's legal representatives to certain newspapers pointing out the truth and asking for the allegations to be withdrawn have simply been ignored. In the circumstances, Ms. Maxwell is now proceeding to take legal action against those newspapers. I understand newspapers need stories to sell copies. It is well known that certain newspapers live by the adage, why let the truth get in the way of a good story. However, the allegations made against me I have warranted entirely untrue and I ask that they stop, said Ghislaine Maxwell. A number of newspapers have shown a complete lack of accuracy in their reporting of this story and a failure to carry out the most elementary investigation or any real due diligence. I am now taking action to clear my name, she said. Media contact. Roscoe. Acuity reputation. Tel +44 203 008 7790. Mod +44 77 78 755 251. Email ross@acuityreputation.com. Media contact Roscoe Acuity Reputation. Tel +44 203 008 7790. Mod +44 77 78 755 251. Email ross@acuityreputation.com. 5. Plaintiff's gratuitous and lurid accusations in an unrelated action. In 2008-2, alleged victims of Epstein brought an action under the Crime Victims' Rights Act against the United States government, purporting to challenge Epstein's plea agreement. They alleged the government violated their CVRA rights by entering into the agreement. 6. 7 years later, on December 30, 2014, Ms. Jaffer moved to join the CVRA action, claiming she, too, had her CVRA rights violated by the government. On January 1, 2015, Ms. Jaffer filed a corrected joinder motion. 7. The issue presented in her joinder motion was narrow, whether she should be permitted to join the CVRA action as a party under Federal Rule of Civil Procedure 21, specifically whether she was a known victim of Mr. Epstein and the government owed them CVRA duties. Yet, the bulk of the motion consists of copious factual details that plaintiff and her co-movement would prove. If allowed to join, Ms. Jaffer gratuitously included Case 18, 2868, Document 275-08/09/2019, 2628223, page 3 of 18.3. Provocative mood, details of her alleged sexual activities as an alleged victim of sexual trafficking. 8. At the time they filed the motion, Ms. Jaffer and her lawyers knew that the media had been following the Epstein criminal case and the CVRA action. While they deliberately filed the motion without disclosing Ms. Jaffer's name, claiming the need for privacy and secrecy, they made no attempt to file the motion under seal. Quite the contrary, they filed the motion publicly. 9. As the district court noted in ruling on the joinder motion, Ms. Jaffer named several individuals, and she offers details about the type of sex acts performed and where they took place. The court ruled that these lurid details are unnecessary. The factual details regarding whom and where the regime was engaged in sexual activities are immaterial and impertinent. Especially considering that these details involve non-parties who are not related to the respondent government. Accordingly, has the unnecessary details shall be stricken. The court then struck all Ms. Jaffer's factual allegations relating to her alleged sexual activities and her allegations of misconduct by non-parties. The court said the striking of the word details was a sanction for Ms. Jaffer's improper inclusion of them in the motion. 10. The district court found not only that the word details were unnecessary but also that the entire joinder motion was entirely unnecessary. Ms. Jaffer and her lawyers knew the motion, with all its lurid details, was unnecessary, because the motion itself recognized that she would be able to participate as a fact witness to achieve the same result she sought as a party. The court denied plaintiff's joinder motion. 11. One of the non-parties Ms. Jaffer named repeatedly in the joinder motion was Ms. Maxwell. According to the word details of Ms. Jaffer included in the motion, Case 18, 2868, Document 275-08/09/2019, 2628223, page 4 of 18.4. Ms. Maxwell personally was involved in a sexual abuse and sex trafficking scheme created by Epstein. Ms. Maxwell approached plaintiff in 1999 when plaintiff was 15 years old to recruit her into the scheme. Ms. Maxwell was one of the main women Epstein used to procure underage girls for sexual activities. Ms. Maxwell was a primary co-conspirator with Epstein in his scheme. She persuaded plaintiff to go to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other co-conspirators coerced dozens of other children. At the mansion, when plaintiff began giving Epstein a massage, he and Ms. Maxwell turned it into a sexual encounter. Epstein, with the assistance of Ms. Maxwell, converted plaintiff into a sex slave. Plaintiff was a sex slave from about 1999 to 2002. Ms. Maxwell also was a co-conspirator in Epstein's sexual abuse. Ms. Maxwell appreciated the immunity she acquired under Epstein's plea agreement because the immunity protected her from prosecution for the crime she committed in Florida. Ms. Maxwell participated in the sexual abuse of plaintiff and others. Ms. Maxwell took numerous sexually explicit pictures of underage girls involved in sexual activities, including plaintiff. She shared the photos with Epstein. As part of her role in Epstein's sexual abuse ring, Ms. Maxwell connected Epstein with powerful individuals so that Epstein could traffic plaintiff to these persons. Plaintiff was forced to have sexual relations with Prince Andrew in Ms. Maxwell's apartment in London. Ms. Maxwell facilitated plaintiff's sex with Prince Andrew by acting as a madam for Epstein. Ms. Maxwell assisted in internationally trafficking plaintiff and numerous other young girls for sexual purposes. Plaintiff was forced to watch Epstein, Ms. Maxwell and others engage in illegal sexual acts with dozens of underage girls. Case 18-2868, document 275-08/09/2019, 2628223, page 5 of 18.5. 12. In the joinder motion, plaintiff also alleged she was forced to have sex with Harvard Law Professor Alan Dershowitz, model scout Gene Bruno, and many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. 13. Plaintiff said after serving for 4 years as a sex slave, she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. 14. Plaintiff suggested the government was part of Epstein's conspiracy when it secretly negotiated a non-prosecution agreement with Epstein precluding federal prosecution of Epstein and his co-conspirators. The government's secrecy, plaintiff alleged, was motivated by its fear that plaintiff would raise powerful objections to the agreement that would have shed tremendous public light on Epstein and other powerful individuals. 15. Notably, the other Jane Doe who joined plaintiff's motion who alleged she was sexually abused many occasions by Epstein was unable to corroborate any of plaintiff's allegations. 16. Also notably, in her multiple and lengthy consensual interviews with Ms. Churcher 3 years earlier, plaintiff told Ms. Churcher of virtually none of the details she described in the joinder motion. 17. Ms. Maxwell's response to plaintiff's lurid accusations, the January 2015 statement. As plaintiff and her lawyers expected, the 4th District Judge Mara in the CVRA action could strike the lurid details of plaintiff's allegations in the joinder motion. Members of the media obtained copies of the motion. 18. At Mr. Orden's direction, on January 3, 2015, Mr. Hill sent to numerous representatives of British media organizations an email containing a quotable statement on Case 18-2868, document 275-08/09/2019, 2628223, page 6 of 18.6. Behalf of Ms. Maxwell. The email was sent to more than 6 and probably less than 30 media representatives. It was not sent to non-media representatives. 19. Among the media representatives were Martin Robinson of the Daily Mail, PPG Independent, Nick Samoa of the Mirror, David Brown of the Times, and Nick Always and Joe N.Q. of the BBC, and David Mercer of the Press Association. These representatives were selected based on their request after the joinder motion was filed for a response from Ms. Maxwell to plaintiff's allegations in the motion. 20. The email to the media members read, to whom it may concern, please find attached a quotable statement on behalf of Ms. Maxwell. No further communication will be provided by her on this matter. Thanks for your understanding. Best. Ross. Roscoe. ACUITY reputation. Jane Doe 3 is Virginia Roberts and not a new individual. The allegations made by Victoria Roberts against Ghislaine Maxwell are untrue. The original allegations are not new and have been fully responded to and shown to be untrue. Each time the story is retold, it changes, with more salacious details about public figures and world leaders, and now it is alleged by Ms. Roberts, that Alan Dershowitz, is involved in having sexual relations with her, which he denies. Ms. Roberts' claims are obvious lies and should be treated as such and not published as news, as they are defamatory. Ghislaine Maxwell's original response to the lies and defamatory claims remains the same. Maxwell strongly denies allegations of an unsavory nature, which have appeared in the British press and elsewhere, and reserves her right to seek redress at the repetition of such old defamatory claims. 21. Mr. Orton, who prepared the January 2015 statement, did not intend it as a traditional press release solely to disseminate information to the media, so he intentionally did not pass it through a public relations firm, such as Mr. Joe's firm, Acuity Reputation. Case 18, 2868, document 275, 08/09/2019, 2628223, page 7 of 187. 22. The January 2015 statement served two purposes. First, Mr. Orton intended that it mitigate the harm to Ms. Maxwell's reputation from the press's republication of plaintiff's false allegations. He believed these ends could be accomplished by suggesting to the media that, among other things, they should subject plaintiff's allegations to inquiry and scrutiny. For example, he noted in the statement that plaintiff's allegations changed dramatically over time, suggesting that they are obvious lies and therefore should not be published as news. 23. Second, Mr. Orton intended the January 2015 statement to be a shot across the bow of the media, which he believed had been unduly eager to publish plaintiff's allegations without conducting any inquiry of their own. Accordingly, in the statement he repeatedly noted that plaintiff's allegations were defamatory. In this sense, the statement was intended as a cease and desist letter to the media recipients, letting the media recipients understand the seriousness with which Ms. Maxwell considered the publication of plaintiff's obviously false allegations and the legal indefensibility of their own conduct. 24. Consistent with those two purposes, Mr. Joe's emails prefaced the statement with the following language: "Please find attached a quotable statement on behalf of Ms. Maxwell, emphasis applied." The statement was intended to be a single, one-time only, comprehensive response, quoted in full to plaintiff's December 30, 2014, allegations that would give the media Ms. Maxwell's response. The purpose of the prefatory statement was to inform the media recipients of this intent. 25. Plaintiff's activities to bring light to the rights of victims of sexual abuse. Plaintiff has engaged in numerous activities to bring attention to herself, to the prosecution and punishment of wealthy individuals such as Epstein, and to her claimed interest in bringing light to the rights of victims of sexual abuse. Case 18, 2868, document 275, 08/09/2019, 2628223, page 8 of 188. 26. Plaintiff created an organization, Victims Refuse Silence, Incorporated, a Florida corporation, directly related to her alleged experience as a victim of sexual abuse. 27. The goal of Victims Refuse Silence was, and continues to be, to help survivors surmount the shame, silence, and intimidation typically experienced by victims of sexual abuse. Toward this end, plaintiff has dedicated her professional life to helping victims of sex trafficking. 28. Plaintiff repeatedly has sought out media organizations to discuss her alleged experience as a victim of sexual abuse. 29. On December 30, 2014, plaintiff publicly filed an entirely unnecessary joinder motion laden with unnecessary, lurid details about being sexually abused as a minor victim by wealthy and famous men and being trafficked all around the world as a sex slave. 30. The plaintiff's alleged purpose in filing the rejoinder motion was to vindicate her rights under the CVRA, expose the elements secretly negotiated non-prosecution agreement with Epstein, shed tremendous public light on Epstein and other powerful individuals that would undermine the agreement, and support the CVRA plaintiff's request for documents that would show how Epstein used his powerful political and social connections to secure a favorable plea deal on the government's motive to aid Epstein and his co-conspirators. 31. Plaintiff has written a manuscript of a book she has been trying to publish, detailing her alleged experience as a victim of sexual abuse and of sex trafficking in Epstein's alleged sex scheme. Case 18, 2868, document 275, 08/09/2019, 2628223, page 9 of 18-9. 32. Republication alleged by plaintiff. Plaintiff was required by interrogatory no. 6 to identify any false statements attributed to Ms. Maxwell that were published globally, including within the Southern District of New York, as plaintiff alleged in paragraph 9 of count I of her complaint. In response, plaintiff identified the January 2015 statement and 9 instances in which various news media published portions of the January 2015 statement in news articles or broadcast stories. 33. In none of the 9 instances was there any publication of the entire January 2015 statement. 34. Ms. Maxwell and her agents exercised no control or authority over any media organization, including the media identified in plaintiff's response to interrogatory no. 6. In connection with the media's publication of portions of the January 2015 statement. 35. Plaintiff's defamation action against Ms. Maxwell. 8 years after Epstein's guilty plea, plaintiff brought this action, repeating many of the allegations she made in her CVRA joinder motion. 36. The complaint alleged that the January 2015 statement contained the following deliberate falsehoods. A. That Jaffer's sworn allegations against Ghislaine Maxwell are untrue. B. That the allegations have been shown to be untrue. C. That Jaffer's claims are obvious lies. 37. Plaintiff lived independently from her parents, with her filing alone before meeting Epstein when Ms. Maxwell. After leaving the Growing Together's rehabilitation facility in 1999, plaintiff moved in with a family of a fellow patient. There she met and became engaged to her friend's brother, James Michael Austrick. She announced it thereafter. Case 18, 2868, document 275, 08/09/2019, 2628223, page 10 of 1810. Rented an apartment in the Fort Lauderdale area with another friend and both worked at various jobs in that area. Later, they stayed briefly with plaintiff's parents in the Palm Beach/Waxahachie, Florida area before Austrick rented an apartment for the couple on Wentworth Drive in Wall Palm Beach. Although plaintiff agreed to marry Austrick, she never had any intention of doing so. 38. Plaintiff knew Morgan High School from June 21, 2000 until March 7, 2002. After finishing the 9th grade school year at Forest Hills High School on June 9, 1999, plaintiff re-enrolled at Wellington Adult High School on June 21, 2000, again on August 16, 2000 and on August 14, 2001. On September 20, 2001, plaintiff then enrolled at Wall Palm Beach High School. A few weeks later, on October 12, 2001, she matriculated at Survivor's Charter School. Survivor's Charter School was an alternative school designed to assist students who had been unsuccessful at more traditional schools. Plaintiff remained enrolled at Survivor's Charter School until March 7, 2002. She was present 56 days and absent 13 days during her time there. Plaintiff never received her high school diploma or GED. Plaintiff and Figueroa went back to school together at Survivor's Charter School. The school day there lasted from morning until early afternoon. 39. During the year 2000, plaintiff worked at numerous jobs. In 2000, while living with her filing, plaintiff held 5 different jobs at a literature reading and research center, Southeast Employee Management Company, the at Mar-a-Lago, Oasis Outsourcing, and Neiman Marcus. Her taxable earnings that year totaled nearly $9,000. Plaintiff cannot now recall either the Southeast Employee Management Company or the Oasis outsourcing jobs. 40. Plaintiff's employment at the Mar-a-Lago Spa began in fall 2000. Plaintiff's father, Sky Roberts, was hired as a maintenance worker at the Mar-a-Lago Club in Palm Case 18, 2868. Document 207-08/09/2019, 2628223, page 11 of 1811. Beach, Florida, beginning on April 11, 2000. Mr. Roberts worked there year-round for approximately 3 years. After working there for a period of time, Mr. Roberts became acquainted with a head of the spa area and recommended plaintiff for a job there. Mar-a-Lago closes every Mother's Day and reopens on November 1. Most of employees Mar-a-Lago, including all employees of the spa area such as spa attendants, are seasonal and work only when the club is open, that is, between November 1 and Mother's Day. Plaintiff was hired as a seasonal spa attendant to work at the Mar-a-Lago Club in the fall of 2000 after she had turned 17. 41. Plaintiff represented herself as a masseuse for Jeffrey Epstein. While working at the Mar-a-Lago Spa and reading a library book about massage, plaintiff met Ms. Maxwell. Plaintiff thereafter told her father that she got a job working for Jeffrey Epstein as a masseuse. Plaintiff's father took her to Epstein's house on one occasion around that time, and Epstein came outside and introduced himself to Mr. Roberts. Plaintiff commenced employment as a traveling masseuse for Mr. Epstein. Plaintiff was excited about her job as a masseuse, about traveling with him and about meeting famous people. Plaintiff represented that she was employed as a masseuse beginning in January 2001. Plaintiff never mentioned Ms. Maxwell to her in filing, Austric. Plaintiff's father never met Ms. Maxwell. 42. Plaintiff resumed her relationship with convicted felon Anthony Figueroa. In spring 2001, while living with Ostich, plaintiff lied to and cheated on him with her high school boyfriend, Anthony Figueroa. Plaintiff and Austric thereafter broke up, and Figueroa moved into the Antioch apartment with plaintiff. When Austric returned to the Antioch apartment to check on his pets and retrieve his belongings, Figueroa in plaintiff's presence punched Austric in the face. Figueroa and plaintiff fled the scene before police arrived. Figueroa was then a convicted felon and a drug abuser on probation for possession of a controlled substance. Case 18, 2868, document 275-08/09/2019, 2628223, page 12 of 1812. 43. Plaintiff freely and voluntarily contacted the police to come to her in 2001 and 2002 but never reported to them that she was Epstein's sex slave. In August 2001 at age 17, while living in the same apartment, plaintiff and Figueroa hosted a party with a number of guests. During the party, according to plaintiff, someone entered plaintiff's room and stole $500 from her shirt pocket. Plaintiff contacted the police. She met and spoke with police officers regarding the incident and filed a report. She did not disclose to the officer that she was a sex slave. A second time, in June 2002, plaintiff contacted the police to report that her former landlord had left her belongings by the roadside and had lit her mattress on fire. Again, plaintiff met and spoke with law enforcement officers but did not complain that she was the victim of any sexual trafficking or abuse or that she was then being held as a sex slave. 44. From August 2001 until September 2002, Epstein and Maxwell were almost entirely absent from Florida on documented travel unaccompanied by plaintiff. Flight logs maintained by Epstein's private pilot Dave Rogers evidenced a substantial number of trips away from Florida that Epstein and Maxwell took, unaccompanied by plaintiff, between August 2001 and September 2002. Rogers maintained a log of all flights on which Epstein and Maxwell traveled with him. Epstein additionally traveled with another pilot who did not keep such logs, and he also occasionally traveled via commercial flights. For substantially all of 30 months of the 22 months, from November 2000 until September 2002, that plaintiff lived in Palm Beach and knew Epstein. Epstein was traveling outside of Florida unaccompanied by plaintiff. During this same period of time, plaintiff was employed at various jobs, enrolled in school, and living with her boyfriend. 45. Plaintiff and Figueroa shared a vehicle during 2001 and 2002. Quintus and Figueroa shared a 93 white Pontiac in 2001 and 2002. Quintus freely traveled around the Palm Case 18, 2868, document 275-08/09/2019, 2628223, page 13 of 1813. Each area in that vehicle. In August 2002, Quintus acquired a Dodge Dakota pickup truck from her father. Figueroa used that vehicle in a series of crimes before and after Quintus left for Thailand. 46. Quintus held a number of jobs in 2001 and 2002. During 2001 and 2002, Quintus was gainfully employed at several jobs. She worked as a waitress at Menino's Restaurant, at Jeffrey's Restaurant, at CCI and Royal Palm Incorporated, and at Roadhouse Grill. She also was employed at Courtyard Animal Hospital at the Mark Tinkwasser DVM. 47. In September 2002, Quintus traveled to Thailand to receive massage training, and while there, met her future husband and eloped with him. Quintus traveled to Thailand in September 2002 to receive formal training as a masseuse. Figueroa drove her to the airport. While there, she initially contacted Figueroa frequently, incurring a phone bill of $4,000. She met Robert Jayapur while in Thailand and decided to marry him. She thereafter ceased all contact with Figueroa from October 2002 until 2 days before Mr. Figueroa's deposition in this matter in May 2016. 48. Detective Riccieri's investigation of Epstein failed to uncover any evidence that Ms. Maxwell was involved in sexual abuse of minors, sexual trafficking or production or possession of child pornography. Joseph Riccieri served as a lead detective from the Palm Beach Police Department, charged with investigating Jeffrey Epstein. That investigation commenced in 2005. Riccieri worked only on the Epstein case for an entire year. He reviewed previous officers' reports and interviews, conducted numerous interviews of witnesses and alleged victims himself, reviewed surveillance footage of the Epstein home, participated in and had knowledge of the search warrant executed on the Epstein home, and testified regarding the case before the Florida State Grand Jury against Epstein. Detective Riccieri's investigation case 18, 2868, document 275-08/09/2019, 2628223, page 14 of 1814, revealed that not one of the alleged Epstein victims ever mentioned Ms. Maxwell's name and she was never considered a suspect by the government. None of Epstein's alleged victims said they had seen Ms. Maxwell at Epstein's house, nor said they had been recruited by her, nor paid any money by her, nor told what to wear or how to act by her. Indeed, none of Epstein's alleged victims ever reported to the government they had met or spoken to Ms. Maxwell. Maxwell was not seen coming or going from the house during the law enforcement surveillance of Epstein's home. The arrest warrant did not mention Ms. Maxwell and her name was never mentioned before the grand jury. No property belonging to Maxwell, including sex toys or child pornography, was seized from Epstein's home during execution of the search warrant. Detective Riccieri, when asked to describe everything that you believe you know about Ghislaine Maxwell's sexual trafficking conduct, replied, "I don't." He confirmed he has no knowledge about Ms. Maxwell sexually trafficking anybody. Detective Riccieri also has no knowledge of Quintus' conduct that is subject to this lawsuit. 49. No nude photograph of Quintus was displayed in Epstein's home. Epstein's housekeeper, Juan Alessi, never saw any photographs of Virginia Roberts in Mr. Epstein's house. Detective Riccieri entered Epstein's home in 2002 to install security cameras to catch a thief and did not observe any child pornography within the home, including on Epstein's desk in his office. 50. Quintus intentionally destroyed her journal and dream journal regarding her memories of this case in 2013, while represented by counsel. Quintus drafted a journal describing individuals to whom she claimed she was sexually trafficked as well as her memories and thoughts about her experiences with Epstein. In 2013, she and her husband created a bonfire in her backyard in Florida and burned the journal together with other documents in her case 18, 2868, document 275-08/09/2019, 2628223, page 15 of 1815. Possession. Quintus also kept a dream journal regarding her thoughts and memories that she possessed in January 2016. To date, plaintiff cannot locate the dream journal. 51. Plaintiff publicly revealed her story, beginning in 2011. Plaintiff granted journalist Sharon Churchill extensive interviews that resulted in seven widely distributed articles from March 2011 through January 2015. Churchill regularly communicated with plaintiff and her attorneys or other agents from early 2011 to the present day. Plaintiff received approximately $160,000 for her stories and pictures that were published by many news organizations. 52. Plaintiff drafted a 144-page purportedly autobiographical book manuscript in 2011, which she actively sought to publish. In 2011, contemporaneous with her Churchill interviews, plaintiff drafted a book manuscript which purported to document plaintiff's experiences as a teenager in Florida, including her interactions with Epstein and Maxwell. Plaintiff communicated with literary agents, ghostwriters and potential independent publishers in an effort to get her book published. She generated marketing materials and circulated those along with book chapters to numerous individuals associated with publishing and the media. 53. Plaintiffs publicly filed Lawrence CVRA pleadings, initiated a media frenzy and generated highly publicized litigation between her lawyers and Alan Dershowitz. On December 30, 2014, plaintiff, through counsel, publicly filed a joinder motion that contained her lurid allegations about Ms. Maxwell and many others, including Alan Dershowitz, Prince Andrew, Jean-Luc Bruno. The joinder motion was followed by a corrected motion and two further declarations in January and February 2015, which repeated many of plaintiff's claims. These CVRA pleadings generated a media maelstrom and spawned highly publicized litigation between plaintiff's lawyers, Edwards and Cassell, and Alan Dershowitz. After plaintiff publicly case 18-2868, document 275-08/09/2019, 2628223, page 16 of 1816. Alleged Mr. Dershowitz of sexual misconduct. Mr. Dershowitz vigorously defended himself in the media. He called plaintiff a liar and accused her lawyers of unethical conduct. In response, attorneys Edwards and Cassell sued Dershowitz who counterclaimed. This litigation, in turn, caused additional media attention by national and international media organizations. 54. Plaintiffs formed non-profit victims refused silence to attract publicity and speak out on a public controversy. In 2014, plaintiff, with the assistance of the same counsel, formed a non-profit organization, Victims Refuse Silence. According to plaintiff, the purpose of the organization is to promote plaintiffs' professed cause against sex slavery. The stated goal of the organization is to help survivors surmount the shame, silence, and intimidation typically experienced by victims of sexual abuse. Plaintiff attempts to promote victims refuse silence at every opportunity. For example, plaintiff participated in an interview in New York with ABC to promote the charity and to get her mission out to the public. Dated January 6, 2017. Respectfully submitted /S/Laura A. Menninger. Laura A. Menninger, AM 1374. Jeffrey S. Pagliuca, Pro Hack Device. Adam Morgan and Foreman, PC 150 East 10th Avenue. Denver, CO 80203. Phone 303.831.7364. Fax 303.832.2628. Menninger at onfall.com. Attorneys for Ghislaine Maxwell. Case 18-2868, document 275-08/09/2019, 2628223, page 17 of 1817. Certificate of Service. I certify that on January 6, 2017, I electronically served this defendant's statement of material undisputed facts pursuant to Local Civil Rule 56.1 via ECF on the following: Sigrid S. McCauley, Meredith Schultz, Lawyers, Shore and Flexner, LLP, 401 East Los Olas Boulevard, SP, 1200, Fort Lauderdale, SL 33301, McCauley at DSSLLP.com. Schultz at DSSLLP.com. Paul G. Cassell, 383 S University Street, Salt Lake City, UT 84112. Castle at Law Utah Edu. Bradley J. Edwards, Farmer, Jesse, Wyson, Edwards, Sisters and Lemon, PL 425 North Andrews Avenue, Speed 2, Fort Lauderdale, SL 33301. Braddock Path to Justice Com. J. Stanley Pottinger, 49 Twin Lakes Road, South Salem, NY10590. Stan Pottinger Radio.com. /S/ Nicole Simmons. Nicole Simmons. United States District Court. Southern District of New York. Ex Virginia L. Jaffer, plaintiff, v. Ghislaine Maxwell, defendant. 15 CV 07433 RWS. Ex declaration of Laura A. Menninger in support of defendant's motion for summary judgment. I, Laura A. Menninger, declare as follows. 1. I am an attorney at law, licensed in the state of New York and admitted to practice in the United States District Court for the Southern District of New York. I am a member of the law firm Adam, Morgan & Foreman, P.C., counsel a record for defendant Ghislaine Maxwell in this action. I respectfully submit this declaration in support of Ms. Maxwell's motion for summary judgment. Point 12. Attached as exhibit is a true and correct copy of an article by Sharon Churcher entitled Prince Andrew and the 17-year-old Girl His Sex, a Send-a Fruit of Written Comedian, DAILYMAIL, dated March 2, 2011. When at trial, defendant intends to produce either a custodian a record relevant to any disputed document or a certification in compliance with either said. R.Z. P803/1902. C said. R.Civ. P56C. Apart from deposition testimony, the majority of non-deposition documents herein were either produced by plaintiff or obtained with releases signed by plaintiff. Case 18, 2868, document 277, 08/09/2019, 2628225, page 1 of 72. 3. Attached as Exhibit B is a true and correct copy of an article by Sharon Churcher entitled Teenage Girl Recruited like Pedophile Jeffrey Epstein Reveals How She Twice Met Bill Clinton, DAILYMAIL, dated March 5, 2011. 4. Attached as Exhibit C is a true and correct copy of a statement on behalf of Ms. Maxwell dated March 9, 2011. 5. Attached as Exhibit D, filed under seal, is a true and correct copy of a corrected motion for joinder, Del v. United States, No. 0880736 Mara/Johnson, S.D. Law. January 2, 2015. 6. Attached as Exhibit E is a true and correct copy of an order denying motion to join under Rule 21, Del v. United States, No. 0880736 Mara/Johnson, S.D. Law. April 7, 2016. 7. Attached as Exhibit F is a true and correct copy of a statement on behalf of Ms. Maxwell dated January 2, 2015. 8. Attached as Exhibit G, filed under seal, are true and correct copies of excerpts from the November 18, 2016 deposition of Roscoe, designated confidential under the protective order. 9. Attached as Exhibit H, filed under seal, is a true and correct copy of plaintiff's response to second request for production into interrogatories and request for admissions, dated July 1, 2016. 10. Attached as Exhibit I, filed under seal, is a true and correct copy of plaintiff's supplemental responses to interrogatory NOS. 6, 12, and 13, dated August 17, 2016, designated confidential under the protective order. Case 18, 2868, document 277, 08/09/2019, 2628225, page 2 of 73. 11. Attached as Exhibit J, filed under seal, is a true and correct copy of the declaration of Ghislaine Maxwell, dated January 6, 2017. 12. Attached as Exhibit K, filed under seal, is a true and correct copy of the declaration of Philip Barton, dated January 6, 2017. 13. Attached as Exhibit L, filed under seal, are true and correct copies of excerpts from the June 23, 2016 deposition of James Alstrick, designated confidential under the protective order. 14. Attached as Exhibit M, filed under seal, is a true and correct copy of plaintiff's passport application, dated January 12, 2001, designated confidential under the protective order. 15. Attached as Exhibit N, filed under seal, are true and correct copies of excerpts from the May 3, 2016 deposition of Legend Jayasa, designated confidential under the protective order. 16. Attached as Exhibit O, filed under seal, are true and correct copies of plaintiff's school records dates stamped GM_00888 and GIUSFREE004981, 88 and designated confidential under the protective order. 17. Attached as Exhibit P, filed under seal, are true and correct copies of excerpts from the June 24, 2016 deposition of Tony Shirua, designated confidential under the protective order. 18. Attached as Exhibit Q, filed under seal, are true and correct copies of excerpts from the November 14, 2016 deposition of Legend Jayasa, designated confidential under the protective order. Case 18, 2868, document 277, 08/09/2019, 2628225, page 3 at 74. 19. Attached as Exhibit R, filed under seal, is a true and correct copy of plaintiff's Social Security records dated October 25, 2016, date stamped GIUSFRE009175, designated confidential under the protective order. 20. Attached as Exhibit S, filed under seal, is a true and correct copy of MARAGO records, date stamped MARALAGO 0001 and MARALAGO 0161 0177. 21. Attached as Exhibit P, filed under seal, is a true and correct copies of excerpts from the May 20, 2016 deposition of Sky Roberts, designated confidential under the protective order. 22. Attached as Exhibit U, filed under seal, is a true and correct copy of the MARAGO Employee Handbook, dated October 28, 1995, date stamped MARALAGO 0178 0243. 23. Attached as Exhibit V, filed under seal, is a true and correct copy of the MARAGO advertisement, date stamped MARALAGO 0086. 24. Attached as Exhibit W, filed under seal, is a true and correct copy of plaintiff's courtyard animal hospital employment application, date stamped GIUSFRE009211, designated confidential under the protective order. 25. Attached as Exhibit X, filed under seal, is a true and correct copy of the Royal Palm Beach Police Department Offense Report date, June 10, 2001, date stamped GM_0078082. 26. Attached as Exhibit Y, filed under seal, is a true and correct copy of the Royal Palm Beach Police Department Probable Cause Affidavit date, November 19, 1999, date stamped GM_01223, 28. 27. Attached as Exhibit G, filed under seal, is a true and correct copy of the Royal Palm Beach Police Department Offense Report date, August 3, 2001, date stamped GM_0777779. Case 18, 2868, document 277, 08/09/2019, 2628225, page 4 of 75. 28. Attached as Exhibit A, filed under seal, is a true and correct copy of the Palm Beach County Sheriff's Offense Report date, June 02, 2002, date stamped GM_0074879. 29. Attached as Exhibit BD, filed under seal, are true and correct copies of David Rogers' flight logs from November 1995 to May 2013, date stamped DR_0001DR0107. 30. Attached as Exhibit CC, filed under seal, is a true and correct copy of excerpts from the June 3, 2016 deposition of David Rogers, designated confidential under the protective order. 31. Exhibit DD left intentionally blank. 32. Attached as Exhibit E, file number C, is a true and correct copy of the Royal Palm Beach Police Citation Tracking Report date, June 19, 2002, late stamp GM_00776. 33. Attached as Exhibit FF, file number C, is a true and correct copy of the Palm Beach County Sheriff's Offense Report, late stamp GM_01202, 28. 34. Attached as Exhibit GG, file number C, is a true and correct copies of excerpts from the June 21, 2016 deposition of Joseph Lecary, designated confidential under the protective order. 35. Attached as Exhibit HH, file number C, is a true and correct copy of the affidavit of Juan PLSE, dated January 13, 2016, late stamped GM_01197, 1201. 36. Attached as Exhibit II, file number C, is a true and correct copy of excerpts from the deposition of Virginia Jaffa taken in Cassell Dershowitz on January 16, 2016, and designated as confidential under the protective order. Case 18, 2868, document 277, 08/09/2019, 2628225, page 5 of 76. 37. Attached as Exhibit JJ, file number C, is a true and correct copy of the log sheet from the January 16, 2016 deposition of Virginia Jaffa taken in Cassell Dershowitz, dated February 11, 2016, and designated by plaintiff as confidential under the protective order. 38. Attached as Exhibit KK, file number C, is a true and correct copy of the Millionaire Playboy's quote manuscript, designated by plaintiff as confidential under the protective order. 39. Attached as Exhibit O, is a true and correct copy of the Victims' Refuse Silence, Incorporated. Articles of Incorporation, dated December 23, 2014, GIUSFRE 001064, 65. 40. Attached as Exhibit MM, file number C, is a true and correct copy of excerpts from the September 8, 2016 deposition of Brittany Anderson, designated confidential under the protective order. I declare on the penalty of perjury that the foregoing is true and correct. Executed on January 6, 2017. S/Laura A. Nenner. Laura A. Nenner. Case 18, 2868, document 277, 08/09/2019, 2628225, page 6 of 77. Certificate of Service. I certify that on January 6, 2017, I electronically served this declaration of Laura A. Nenner in support of defendant's motion for summary judgment via ECF on the following: Sigrid S. McCauley, Meredith Schultz, Wars, Shore and Flexner, LLP, 401 East Los Olas Boulevard, ST, 1200, Fort Lauderdale, SL33301, McCauley at DSSLLP.com, Schultz at DSSLLP.com, Paul G. Cassell, 383 University Street, Salt Lake City, UT 84112, Castle at La Utah Edu, Bradley J. Edwards, Farmer, Jaffe, Wyson, Edwards, Sisters and Lehrman, PL 425 North Andrews Avenue, ST, 2, Fort Lauderdale, SL 33301, Brad at PathToJustice.com, J. Stanley Pottinger, 49 Twin Lakes Road, South Salem, NY10590, StamPottingerRadio.com, /S/Nicole Simmons, Nicole Simmons. Case 18, 2868, document 277, 08/09/2019, 2628225, page 7 of 7. This document is CONFIDENTIAL under the court's protective order, DE 62, 1. United States District Court, Southern District of New York. Virginia L. Jaffa, plaintiff, case now. 15 CV 07433 RWS. V. Gisela Maxwell, defendant. Underline 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 slash. Pursuant to Federal Rules of Civil Procedure 26, 33, 34, plaintiff hereby serves her responses and objections to defendant's second set of discovery requests and serves her answers to defendant's request for admission. General objections. Defendant's discovery requests violate Rule 33, said. R. P, which provides a party may serve on any other party no more than 25 interrogatories, including all discrete subparts, in that defendant has served a total of 59 interrogatories in this case, including subparts, in violation of Rule 33. Ms. Jaffer objects to defendant's second set of discovery requests to the extent they seek information that is protected by any applicable privilege, including but not limited to attorney-client privilege, work product privilege, joint defense privilege, public interest privilege, and any other applicable privilege. Case 18, 2868, document 278, 08/09/2019, 2628230, page 71 of 648. This document is CONFIDENTIAL under the Court's Protective Order, DE 62-5. On hundreds, if not thousands, of matters, and collectively has well over 100 years of combined practice experience. Accordingly, I request that each of these attorneys list all communications with the media as facially overbroad. Additionally, Ms. Jaffer objects to this interrogatory because a response would cause Ms. Jaffer the incredible and undue burden of having to catalog literally hundreds of communications that she has already produced in this case. Moreover, Ms. Jaffer objects because this interrogatory calls for the production of documents that are relevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Communications with the media regarding cases that bear no relation to the subject matter of this case from decades in the past are facially invalid and not calculated to lead to the discovery of admissible evidence. Ms. Jaffer additionally objects to the extent that this interrogatory seeks the communications of her attorneys, any author, reporter, correspondent, columnist, writer, commentator, investigative journalist, photojournalist, newspaper person, freelance reporter, stringer, or any other employee of any media organization or independent consultant as such interrogatory is overly broad and unduly burdensome. Furthermore, Ms. Jaffer is not obligated to produce anything currently in the possession of defendant Maxwell or her attorneys. Notwithstanding such objections, Ms. Jaffer has already produced her responsive communications, which are found in document states labeled GIUSFRE 0000001 to Jaffer 0075666. 6. Identify any false statements attributed to Ghislaine Maxwell which were published globally, including within the Southern District of New York as you contend in paragraph 9 of count I of your complaint, including Case 18, 2868, document 278, 08/09/2019, 2628230, page 72 of 648. This document is CONFIDENTIAL under the Court's Protective Order, DE 62-6. The exact false statement, via the date of its publication, see the publishing entity and title of any publication containing the purportedly false statement, via the URL or internet address for any internet version of such publication, and the nature of the publication, whether in print, internet, broadcast or some other form of media. Response to interrogatory now. 6. Ms. Jaffer objects because the information interrogatory is in the possession of defendant who has failed to comply with her production obligations in this matter and has failed to comply with her production obligations with this very subject matter. See document request now. 17 from Ms. Jaffer's second request for production of documents to defendant Ghislaine Maxwell. Point 1. Maxwell has not produced all URL or internet addresses for any internet version of such publication that she directed her agent, Roscoe, to send. 1 request now. 17 stated, produce all documents concerning any statement made by you on your behalf to the press or any other group or individual, including draft statements concerning Ms. Jennifer, I.U., Roscoe, or any other individual from 2005 to the present, including the dates of any publications, and if published online, the Uniform Resource Identifier, URL, address. In response, defendant stated Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative. Ms. Maxwell also objects to this request to the extent it calls for information that exists within the public domain, the internet or in public court records in which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, and less expensive. Ms. Maxwell further objects to this request to the extent it seeks documents or information protected by the attorney/client privilege, the work product doctrine, or any other applicable privilege. Ms. Maxwell is not producing documents that are available in the public domain. Ms. Maxwell has been unable to locate any additional documents responsive to this request. Case 18, 2868, document 278, 08/09/2019, 2628230, page 73 of 648. This document is CONFIDENTIAL under the Court's Protective Order, DE 62-7. Ms. Jennifer further objects because the information requested above is in the possession of defendant's agent, who caused the false statements to be issued to various media outlets. Ms. Jennifer has not had the opportunity to depose Maxwell's agent Roscoe, therefore, this answer remains incomplete. Consequently, Ms. Jennifer reserves the right to modify and/or supplement her responses, as information is largely in the possession of the defendant and her agent. Ms. Jennifer objects to this interrogatory in that it violates Rule 33 as its subparts, in combination with the other interrogatories, exceed the allowable 25 interrogatories. Ms. Jennifer objects to this request because it is in the public domain. Ms. Jennifer also objects in that it seeks information protected by the attorney-client/work product privilege and any other applicable privilege stated in the general objections. Notwithstanding such objections, Ms. Jennifer has already produced documents responsive to this request, dates labeled GIUFFRE 0000001 to GIUFFRE 0075666, and supplement such responsive documents with the following list of publications. While the identification of an exhaustive responsive list would be unduly burdensome in an effort to make a good faith effort towards compliance, Ms. Jennifer provides the following examples, which are incomplete based on the aforementioned reasons. Date nature publicity. In entity. Statement/URL. January. Y2, 2015. Internet Ross. Go. Jane Doe 3 is Virginia Roberts and not a new individual. The allegations made by Victoria Roberts against Ghislaine Maxwell are untrue. The original allegations are not new and have been fully responded to and shown to be untrue. Each time the story is retold it changes, with more salacious details about public figures and world leaders, and now it is alleged by Ms. Roberts that Alan Dershowitz is involved in having sexual relations with her, which he denies. Ms. Roberts' claims are obvious lies and should be treated as such and not publicized as news, as they are defamatory. Ghislaine Maxwell's original response to the lies and defamatory claims remains the same. Maxwell strongly denies allegations of an unsavory nature, which have appeared in the British press and elsewhere, and reserves her right to seek redress at Case 18, 2868, document 278, 08/09/2019, 2628230, page 74 of 648. This document is CONFIDENTIAL under the Court's Protective Order, DE 62-8. The repetition of such old defamatory claims. January. Y3, 2015. Internet Telegraph. http://www.telegraph.company/nurse/royal family/11323872/Prince Andrew denies having relations with sex slave girl HTML. January. Y4, 2015. Internet Express http://www Express Company /news/road/550085 /Ghislaine Jeffrey Epstein, not Madam Painful Florida Court Case Prince Andrew January. Y3, 2015. Internet Daily. Mail. http://www.mail company /news/article 2895366/Prince Andrew Login Element Easy Jeffrey Epstein Palace denies claims law tried use influence help billionaire painful 2008 Police Pro HTML January. Y3 2015 Internet Huffington on post http://www.huffingtonpostcompany /2015/01/03/Nuka York Sex Abuse Claims _N_6409508 HTML January. Y4 2015 Internet Juice News Online http://www.jewishnewscompany /Prince Andrew Sex Scandal /January. Y2 2015 Internet Bulletin News http://www.feudalcommunewscompany /news/national/11700192 Palace denies Andrew SX case claim /January. Y5 2015 Internet /Bronca Street Nye Daily News http://www.mcgillnews.com/news/road/ alleged accused supplying Prince Andrew article 1.2065505 January. Y5 2015 Internet /Bronca Same date. UK http://www.company /video/Ghislaine Maxwell declines to comment on Prince Andrew allegations 518587500/ Case 18 2868 Document 278 08/09/2019 2628230 Page 75 of 648. This document is CONFIDENTIAL under the Court's Protective Order DE 6243. Respectfully submitted. Wars, Shore and Flexner LLP. I/S/Sigrid McCauley. Sigrid McCauley, Pro Hack Lice. Meredith Schultz, Pro Hack Lice. War, Shore and Flexner LLP. 401 Los Angeles, Suite 1200. Fort Lauderdale, SL33301. Telephone 954-356-0011. David Wars. War, Shore and Flexner LLP. 333 Main Street. Armonk, NY10504. Bradley J. Edwards, Pro Hack Lice. Farmer, Jesse, Wyson, Edwards, Sisters and Airmen, PL 425 North Andrews Avenue, Suite 2. Fort Lauderdale, Florida 33301. Telephone 954-524-2820. Paul G. Cassell, Pro Hack Lice. S.J. Quinney College of Law. University of Utah. 383 University St. Salt Lake City, UT 84112. Telephone 801-585-5202. Certificate of Service. IHEREVYCERTIFY that on July 1, 2016, I electronically sent the foregoing document to the Council below via email. Laura A. Menner-esque. Jeffrey Pagliuca-esque. Adam Morgan and Foreman, PC 150 East 10 PH Avenue. Denver, Colorado 80203. Tel 303-831-7364. Fax 303-832-2628. Email lemonmurat@on.com. Southern District of New York. Ex Virginia L. Jaffer, plaintiff, v. Ghislaine Maxwell, defendant. 15 CV 07433 RWS. Ex Declaration of Philip Barton. I, Philip Barton, declare as follows. 1. I am a solicitor of the Senior Courts of England and Wales, based in London, England. 2. I am submitting this declaration in support of Ghislaine Maxwell's motion for summary judgment in this action. 3. I am not authorized to and do not waive Ms. Maxwell's attorney-client privilege. 4. I have represented Ms. Maxwell since 2011 regarding the allegations made by Plaintiff Virginia Jaffer as published in the United Kingdom. I continue to be retained in this regard. I am familiar generally with the subject matter of this action. 5. I first represented Ms. Maxwell in this matter over the weekend of 5th and 6th March 2011, about the time when various UK national newspapers, in hard copy and online, published numerous and provocative allegations made by the plaintiff Virginia Jaffer against Ms. Maxwell. The articles by Sharon Churcher were among those published in this time frame. 6. I instructed British press agent Roscoe to assist me in representing Ms. Maxwell. 1. Case 18, 2868, document 278, 08/09/2019, 2628230, page 85 of 648-7. I caused to be prepared a statement to respond to the articles that appeared in the British press over the weekend March 5 and 6, 2011, and thereafter. I directed Mr. Joe to distribute the statements to various media outlets that had published articles. 8. On December 30, 2014, Ms. Jaffer made numerous salacious and improper allegations against Ms. Maxwell in a joinder motion publicly filed in a civil case involving Jeffrey Epstein. Shortly afterward, the British media gained access to the motion and began inquiring about Ms. Maxwell's response. 9. I continued to represent Ms. Maxwell at that time and I coordinated the response to the media. I again instructed Mr. Joe to assist me. 10. In liaison with Mr. Joe and my client, on January 2, 2015, I prepared a further statement denying the allegations, and I instructed Mr. Joe to transmit it via email to members of the British media who had made inquiry about plaintiff's allegations about Ms. Maxwell. Attached as Exhibit A1 is an email containing a true and correct copy of this statement. The statement was issued on my authority. Although it is possible others suggested or contributed content, I prepared the vast majority of the statement and ultimately approved and adopted all of the statement as my work. 11. As is evident from the timing and the typographical errors in the statement, I prepared the statement in haste. I was not in the office on 2nd January 2015 as it was the Friday immediately after New Year's Day, which is a public holiday. Most people put 2nd January off in many business closed that day. I don't now recall where I was that day, but I was hard to reach, and that indicates I was out with my family. I therefore would have prepared the statement in a hurry. I recall that I wanted to get a statement out as a matter of urgency. 12. I recall that immediately after Ms. Jaffer's motion was filed, media representatives began contacting Mr. Joe and requesting Ms. Maxwell's response to Ms. Jaffer's allegations too. Case 18, 2868, document 278, 08/09/2019, 2628230, page 86 of 648 of criminal and other misconduct on Ms. Maxwell. I believe an immediate response was imperative, even though this was happening in the midst of the holidays in the United Kingdom. My communications with Mr. Joe and with Ms. Maxwell were Stop me if you've heard this one. What is the most selfish pig on the highway called? A road dog! How funny, and one below me.